I want to welcome everyone to Resolve Manitoba's webinar entitled The Co-Occurrence of Parental Alienation Claims and Intimate Partner Violence in Family Court, Theory and Practice. I'll say a little bit more about the project, but briefly, this webinar relates to a project that we're engaged in, funded by the Public Health Agency of Canada, that's entitled Supporting the Health of Survivors of Family Violence in Family Law Proceedings. But before I say much more, I would like to do a land acknowledgement. So Patricia, if you could advance the slide. So it is important that we recognize the lands that we're on, especially in terms of, recognizing the importance of reconciliation and working well with our Indigenous communities and stakeholders. So I would like to acknowledge that the Resolve Manitoba, along with the University of Manitoba campuses, are located on original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories, we acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. And I would encourage you all to think for a second what lands you are situated on or are visiting today. Next slide, please, Patricia. So again, welcome everyone to our webinar today. My name is Kendra Nixon, and I'm the director of the Resolve Network. I'm also associate professor in the Faculty of Social Work at the University of Manitoba. Today, we're providing a webinar on parental alienation, a concern that we have been seeing for the last number of years. The use of parental alienation claims and the serious negative impact that has on survivors of intimate partner violence and their children. So again, this is part of a Public Health Agency of Canada study that Resolve is involved in, along with 4 other centers of the Alliance. The Alliance is a consortium of 5 research centers of gender-based violence in Canada. We are the direct result of the Montreal massacre, where the federal government provided monies to develop 5 research centers across the country. So we have sister organizations in New Brunswick, Quebec, London. Resolve is in the Prairies, as well as BC. So the study that we're speaking about today is the Supporting the Health of Survivors of Family Violence in Family Law Proceedings and Community of Practice. It's about bringing a community of practice of experts. We're speaking broadly to include those working in the family law or legal sector, those working in family violence, so shelter workers, victim services workers, police, as well as those with lived experience, so survivors of intimate partner violence. And we're bringing people together so that we can enhance support to survivors of violence through the family law system by increasing opportunities for training, for collaboration, and for coordination, and for just really kind of getting together. And so hosting webinars is one of our main venues of providing training and education. And so this being one of those webinars. Next slide, please, Patricia. So before we begin, I do want to acknowledge our 3 amazing speakers today. First, we'll have Dr. Peter Jaffe, then Robin Kazina, and then Justice Laurie Merwalt. I also want to thank our funders, not only the Public Health Agency of Canada, but the Prairie Action Foundation, who funds the Resolve Network, as well as Ashley Holler, who has is a research technician and is coordinating the Community of Practice study, and Patricia Carasoni, who is our digital communication specialist and is really responsible for making sure our webinars run beautifully and smoothly. And of course, I'd like to acknowledge and thank the audiovisual team at the University of Manitoba. Next slide. So just a few guidelines before we begin. We are recording this webinar so we can post on the Resolve website as well as the Alliance website as well. Parts of it may not be included, including some videos we may be showing. You all have your microphone muted and have your video turned off during the entire webinar. There will be a question and answer period after the 3 speakers, so at the very, very end. And if you have any questions, you can direct them into the chat where only I will see, and I will be moderating those questions at the end. Next slide. Okay, so here is kind of today's agenda. So we're going to start with Peter. Peter will give about a 20-minute presentation, followed by Robin, and then we will conclude with Justice Merwald. And again, about 3:05, we're going to have about a 20-minute question and answer period, followed by some brief closing remarks. And so the webinar will be done at 3:30 Central Time. Next. And I will alert you to some resources that we've put together for this webinar, in addition to the notes that the presenters may have. These will be available on the Resolve website. As well, I want to draw your attention to an upcoming international website, an international webinar on parental alienation, and we do have that link. And I will believe both of these links will be available in the chat as well. Yeah, okay. So we're going to start with 2 polls. We will kind of want a sense of who is attending today. So if I can ask the audiovisual team to start those. So the first question is, where are you from? Where are you joining us today, in Canada or across the globe perhaps? And secondly, what is your current profession, area of practice or background? And so I'll give about 30 seconds to a minute for people to answer those. Okay, so we're seeing that the majority are from Manitoba and Ontario, but we have folks across the country and some from the US or other countries. That's wonderful. And in terms of people's background, so we have quite a few lawyers attending, advocates for survivors, survivors themselves, and other. Okay. All right, thank you for that. Okay, so today, again, we have 3 speakers who will be speaking on parental alienation and family law issues. And I'm going to briefly introduce each of these speakers now. So I'm just going to kind of paraphrase, and then I'll have Peter start, and then we'll have Robin present, and then conclude again with Justice Merwald. So I'll introduce Peter first. Dr. Peter Jaffe is a psychologist, professor emeritus, and one of the founding members of CREVAC, the Center for Research and Education on Violence Against Women and Children at Western University in London, Ontario. Many of you will know Peter is one of the world's leading experts in children's exposure to domestic violence and has worked with court systems around North America to improve the responses to survivors of intimate partner violence and their children. Peter is also one of the principal investigators on this Public Health Agency of Canada study. So welcome, Peter, and thank you. Robin Kazina is a family law lawyer and partner with Taylor McCaffrey in Winnipeg. Along with a law degree, Robin also holds a bachelor's in social work and a master's degree in social work. Robin teaches at the Faculty of Law at the University of Manitoba and has served as a past chair of the Manitoba Bar Association Family Law Section and Women's Lawyers Forum. Robin is dedicated to raising awareness of the intersection between family violence and family law, and is involved in educating the bar about family violence issues and recent changes to the Divorce Act that are relevant to family violence related issues. And I'm happy to say that Robin is also a member of our Winnipeg Community of Practice team. Lastly, I want to introduce Justice Laurie Merwald. Justice Merwald was appointed to the Manitoba Court of Queen's Bench in 2016. Prior to her judicial appointment, Justice Merwald practiced family law, child protection, civil litigation, First Nations governance, employment law, and human resources. Justice Merwald was also an adjudicator under the Indian Residential Schools Settlement Agreement. She has served on a number of important committees related to child protection and family law matters. So again, I want to welcome our 3 speakers. Next slide, or I think that is the end of the slides, and I will have Peter present if you're ready, Peter.
I was born ready.
Yes, I know you were. So just to remind, each presenter has 20 minutes, and I will give you the cue a couple minutes before that. And I forgot to say that Peter is also a comedian. Go ahead, Peter.
Thank you. Thank you for the kind introduction, Kendra. And pleased to be here. And it's great to see the number of people that registered for this session and the very diverse backgrounds. Obviously, we have lawyers and survivors and many other groups represented. This issue is probably one of the hottest issues right now in family court. As many of you hear the words alienation and alienating behavior and resist, refuse dynamics, this is a major issue that everyone in the field is dealing with as a survivor, as a judge, as a custody evaluator or mediator. It's a bit overwhelming, and we can probably spend 4 days on this, but we'll do our best over the next hour and a half. So this is a growing debate. If there's any doubt that this is increasing, if you look at this slide, you can see the number of cases that are appearing in US courts. Same issue in Canada. This article, although it's dated, if we continue this graph, it continues to go up, as this is a major issue that we're seeing in family courts across Canada. And I just want to put this into context. Everyone recognizes that alienation is a real problem, that obviously we hope that parents who separate can work together and try to continue as co-parents. We tell parents repeatedly they're separating as spouses and intimate partners. They're going to be parents forever. We tell parents that exposure to conflict is harmful, and we tell parents that it's important that children have a good relationship with both parents. And we certainly, nobody working in the court system supports turning children against the other parent. We know that's harmful, and any parent involved in any willful campaign to undermine the other parent is clearly acting outside the children's best interest. So these are things that are widely recognized and known. However, alienation should not be capitalized unless it's the beginning of a sentence. Parent alienation should be not capitalized. There's no such thing as parental alienation syndrome, even though it's been promoted and people have tried to get this part of DSM-5 and the World Health Organization. This is not a medical or psychiatric disorder. And I emphasize that because I'm still reading reports from parts of Canada and the US where somebody is testifying to say they've made a diagnosis of parental alienation syndrome. There's no consensus on definition of how to identify or reliably assess alienation, and there's no agreed upon valid intervention. And I'll come back to that point. And alienation is very charged. I call it radioactive because it's a term that's being used that implies a conclusion. And most often when we see problems with children, there are usually multiple factors that need to be understood. And I want to give you just a 1-minute example. This is a video I'm going to play from Hollywood, a movie that's now 21 years old. Pay It Forward. In this scene, Helen Hunt is married to an abuser, John, played by Bon Jovi. She's telling him, they're trying to reconcile and things don't go well. He wants to move back in the bedroom, and they had some agreement where they're not going to be sleeping together. But I want you to watch the conflict, and I want you to watch how their son Trevor deals with the conflict, and ask yourself these questions. What has Arlene done, played by Helen Hunt, to turn Trevor against his father, and how is Trevor affected? So in that short clip, just some initial reflections. Sometimes a picture is better than 1,000 words. And obviously, you think about what Arlene has done to turn Trevor against his father, because that's the question that Ricky's asking in this clip. What have you done to turn him against me? which is a common question. And obviously for Ricky, the answer is you've managed to turn your son against you all by yourself. And you ask yourself about how is Trevor affected. Obviously, Trevor is locking himself in his room and turning up the music. He's also, as you see at the end, as we drift away from that scene, he's wondering when this is going to happen again because he's seen this cycle repeatedly. And it's important to think about the fact that children are affected by exposure to domestic violence or intimate partner violence. Even though he's not an eyewitness, he's certainly hearing everything, and he's seeing the aftermath of the violence on his mother. Now, that scenario is pretty obvious. Everybody gets physical violence, and it's pretty clear, it's obvious, but the challenge we have is the law has changed, and we're now consider family violence to take many forms, including coercive control. So one of the reasons why this topic is particularly important because the Divorce Act has changed. Most provincial and territorial legislation has changed to match these changes. And we now recognize coercive or controlling behavior that causes a family member to fear for their safety is significant. And we're now considering the fact that children can experience family violence by having it directed against them, seeing or hearing it the way you saw Trevor in this scene, seeing a family member scared or injured. All these things are now family violence and child abuse under the Divorce Act. So I think our challenge is now going beyond physical violence and really understanding coercive control. When we think about how children react to these situations, children may resist and refuse for many reasons. Obviously, if there's a credible allegation of domestic violence, a parent may have a reasonable basis in fact to be protective and concerned about contact with the other parent. Children may be anxious and resist or refuse contact with a parent, and it may be a justified rejection. If the child's rejection appears disproportionate to the child's actual experience, then we might have concerns about alienation, but it's important to remember that there are multiple factors that we have to be thinking about. These are factors outlined in a recent article by Barb Fiddler and Nick Balla about the multiple factors. And again, more people in the field now use the term children resist and refuse contact rather than using the word alienation because of its radioactive nature and the fact that it implies a conclusion. There may be ages, may be related to the child's age, temperament, maybe the amount of conflict they were exposed to, may be related to sibling relationships. They may have one parent may be the favorite parent because of match of personality and interests. One parent may be rejected because of some of their conduct in the past. The litigation process may lead children to decide they have to pick a parent and stick with them because of the impact of being drawn into litigation. Third parties may make things worse in terms of professionals who get aligned or extended family. And there may be a lack of any functional co-parenting. Even though we hope and wish for co-parenting, the reality is that 20% of parents will never be co-parents, and they're going to need other kinds of remedies in these situations. The 20% of parents who spend a lot of time in court are not headed towards shared parenting or co-parenting, and they're going to need some pretty structured parenting plans developed by the court or by professionals who are working with those parents. Cases that are very concerning are ones that raise issues about domestic violence. And what we're seeing in courts now, that it's very common to have allegations of parental violence, parental alienation made by a person who's been accused of domestic violence. And what we also see, one of the patterns we're talking about today, is that when a parent, most often a woman, is alleging abuse by her partner, she's then blamed for turning the children against him, when in fact his own conduct may be the problem in that relationship. Research, and this is a citation you see at the bottom of the slide, research actually suggests if anyone, it's actually the abuser who may ultimately try to turn the children against the victim parent. Again, we know that 80% of parents don't spend very much time in court and resolve their conflict, and they resolve their differences through collaborative lawyers, through parent education programs, through mediation. So 80% of parents find a way to resolve their differences. 20% end up in court. And obviously, when we look at the parents that create the greatest concern for us, are those parents where there's a history of violence, also often maybe issues around mental health issues, addictions, criminality. So there's multiple reasons, and those are the cases that create the significant concern and significant court time as professionals, court-related professionals and judges try to sort through allegations of alienation or domestic violence and justified rejection. There's an increasing concern that if people are focused on alienation, they start to identify alienation early, they label it, and becomes a conclusion. And certainly there's a concern, and this is well cited by Mark Twain, who said, if the only tool you have is a hammer, then everything looks like a nail. If you have alienation in your mind and your heart, and that's the information you're looking at repeatedly, pretty soon everything the other parent has done is going to be labeled as potentially alienating behavior. And in fact, we overlook important factors related to parenting history, the nature of litigation, the history of child abuse, trauma, the misuse of alienation to undermine protective parents. So there's so many issues we have to be looking at. There's been a number of scales that have developed. This is one example of common warning signs of alienation, a recent publication by Barb Fiedler and Nick Balla. And obviously these are important things to look at in the absence of context. However, if there is domestic violence and a parent is genuinely concerned, most of the warning signs you see here are also potentially warning signs of a parent who's been traumatized and fearful and concerned about the other parent. So one parent's attempt to develop a safety plan for themselves and their children will be the other parent's interpretation of potential alienation, which are really important things to sort through. It's important to note that although people do their best with existing tools and clinical knowledge, there's no research to date that has actually differentiated between children who are estranged from a parent in response to that parent's behavior, as opposed to the preferred parent's illegitimate influence. We often jump from making allegations about alienation to thinking about different interventions. And a sober second thought here is I think we often intervene without thinking about first doing no harm. And I'm concerned with the number of interventions I'm seeing across North America that are unproven and significant violation of children's rights. We're seeing an increasing concern about who speaks for the children. I think we're falling way short of the UN Declaration on the Rights of the Child in Canada, which we have adopted. I see court cases where there's a lot of confusion on the part of lawyers and judges as to who's actually speaking for the child. Is it supposed to be their counselor? Is there a parenting evaluation? Or should a child have independent counsel and an advisor? And there's a great learning brief provided, I have a citation to here, provided by retired Justice Martinson and Judge Raven on importance of actually implementing children's rights.
Peter, you have 2 minutes.
Okay. I just want to say it's important that we think about children's rights and that children are no longer property to be shared by parents, but we want to recognize, as this quote does, that children have their independent rights, and that needs to be recognized by the court. One of my concerns is having children forced into treatment programs. And again, there's two quotes here. You'll look at these slides at your leisure that'll be provided by Resolve. But clearly, we don't have the outcome evaluation to use many of the programs that we do, and many of the programs that are being suggested to treat potential alienation require custody reversals, and there's actually no research to suggest that this may be helpful. And many cases, we're doing things to children which violate their basic rights. Children need to be engaged in an age-appropriate way, based obviously on their maturity, to make sure they have consent for treatments that are being offered. There's no general age of consent, but obviously we depend on a young person's maturity and knowledge and their understanding and the potential consequences of them not consenting. And I think we need to think about that more and more. I have a case in Quebec right now where a judge removed children from a mother who wasn't promoting contact with a father, put children in a group home, and the children were in that group home for over 2 years. If they had committed an armed robbery, they would be out in less time than they were by this judge's order in terms of an attempt to treat alienation from an otherwise loving and caring parents. Clearly, the children needed a relationship with their father, but the solution was much worse than the presenting problem. Clearly, we need to look for solutions. Part of it involves ongoing judicial legal education programs, early intervention. I know we'll hear more about this shortly, and enhanced standards of practice for court-related professionals, and certainly better access to legal advice and representation for children. So in closing, although many people across the country are becoming obsessed with the issues around alienation, I think we need to start watching more than one television station and get our news and research from multiple sources. And I think we need to think through some of the dangers and harm and the labels we're providing children and parents, and also the interventions we're imposing on children and families. I look forward to questions after the next two presentations. Thank you.
Great, thank you, Peter. I know it's a lot of information to get through in 20 minutes, but I think you set a really nice foundation for the two next presenters, as well as our question and answer period. So Robin, if you want to get your slides up, and I'll just respond to a question and answer, I know, or some questions. I know many of you have asked about having these slides available. The slides for the presentations will be available on the Resolve website, as well as the Alliance website, which we will post at the end. Again, we may not be able to post the video that Peter showed. So Robin, whenever you're ready, you have 20 minutes.
Thank you. Thank you for this opportunity to present, and Peter, for your presentation. It's really eye-opening, and I hope to pick up on some of the themes in mind from more of a practical perspective from a family law practitioner. So just like Peter had presented on, alienation is often, a word that is thrown around a lot by lawyers in cases. And my first kind of reflection, on having worked with these cases, and also many cases where family violence and where a child is refusing contact intersect, you really need to figure out what is going on. Most often the term alienation is used as a conclusion, right? And these often intersect. A high conflict case is not always an alienation case, but it often intersects. Or is it a parental affinity, where a child has an affinity to one parent? Or is it a child who's aligned with a parent? Or is there a justified rejection and estrangement? So there's a lot going on cases where children are resisting contact that needs to be really investigated. So as a family lawyer, the two situations that we normally see are either a survivor who's accused of alienation, where the child's resisting contact, for legitimate reasons, or the abuser is attempting or has alienated a child from the survivor as a continued method of their control. I have to say in practice, from my perspective, we see more of the cases where survivors are accused of alienation. And that is very common where an abuser that is having difficulty with contact with the children, that the really justification will be, oh, they're alienating the children. There are, of course, very, significant and serious cases where abusers alienate the children from the survivor. But I do have to say that we see that, I think, a little less often. Really, because of course, though, that does happen. Sometimes children will do what they do need to do to survive, right? And align themselves with the abuser. And in those cases where the children are alienated from the survivor, often what I've seen is that starts even before the separation. I had a case with, a teenage boy who really had picked up on the unhealthy views of his mother that came from his father. And it was really quite tragic because, that was in place and building up years before the separation. In that situation, he was resisting contact with his mother because he was sort of brainwashed by the unhealthy views of the abuser. But what I'll be sort of focusing on more is the situations that we see, which are more common, where alienation is a word that's thrown around as a conclusion against a survivor, where a child is resisting contact for legitimate reasons. So the first thing, of course, for lawyers is that you need to know about the family violence. I think a lot of people will assume a client is going to come into the first interview and tell you about it. I know that's definitely not the case. And what this chart shows is how often lawyers and judges are screening for family violence. This came from a report that was done, a paper that was done by the federal government. And here you'll see almost always, it's only about half of lawyers that always screen. And on here, it was 34.4% of judges. Of course, we do have, really amazing judges like Justice Mirwalt, who is very attuned to the issue of family violence and does ask. But you'll see, even when people are trying to do the best they can, often they're not even asking about the existence of family violence. And of course, that's not only important for cases of alienation, it's important for all family law cases. So recently, the federal government finalized the help toolkit for lawyers to help identify family violence. And there was a lot of great academic literature related to the development and finalization of the toolkit, which of course said that there's many reasons that clients don't voluntarily disclose. Lawyers are intimidating. Coming into a law office for the first time about something so intimate in your life can be very difficult for people. And I just always, when I think about screening and questions, I always envision, the picture of an iceberg. We see, only a little bit of people's very complicated lives often and nuanced lives when they come to us. And it's our job to be, I think, understanding of that and take a systemic and holistic approach in understanding where they are and what they've experienced. And of course, the importance of training and education. I kind of see it as, the police have a domestic violence unit, right? And I've had clients who have disclosed some significant violence to me. And it's always my practice, if I can, to put them in touch with the domestic violence unit, because they send an unmarked car, they they dress in plain clothes, and they are so trained in the area to work and identify the issues. I kind of really see the same obligation on family lawyers to have that level of understanding and education when we're dealing with such sensitive issues in people's lives. So I'm just gonna, my next couple of slides, talk about two scenarios. One where, as a family lawyer, you have a client who's a survivor accused of alienation. And the other scenario where your client where alienation is happening in the reverse. So when you have a client who's a survivor who's accused of alienation, Again, you'll see this theme throughout, that alienation is often a word used too often as a conclusion, but you really want to get a hold of what the narrative is immediately on why the child is resisting contact. And of course, you're often up against, I think, sometimes gendered stereotypes and assumptions. Again, for my presentation, I'm just going to be, assuming it's the mother, father, and it's the mother who's the survivor of family violence. Of course, that is not always the case, but that's the majority of the cases we see. Because often in alienation cases without family violence, I think mothers will sometimes have more be primary parents before a separation, and when there are true alienation cases, I think it's more common that it is mothers who are alleged to be alienators. And it's really to get a hold of that narrative, to bring the history of the abuse to the forefront and present it in a comprehensive manner. And I'm going to later kind of pick up on the Divorce Act amendments and show how really it, is the lawyer's job to share the history and the facts and the story of that family in light of the expanded definition of family violence under the Divorce Act. Of course, you have to understand the type of violence to help in appropriate parenting arrangements. There's different types of family violence, and there are some situations where there has been family violence, but that doesn't mean that contact still cannot be facilitated with the abuser. And so just to differentiate the cases where the child may be picking up on the fear of the survivor, not to say, of course, that children are affected indirectly by family violence, but they're sort of in developing a parenting plan with the survivor and putting some contact in place in appropriate cases to differentiate sort of the history of the violence and whether or not the child is exacerbating sort of their fear by enmeshing themselves with the survivor. And of course, to ensure safety first for the child, the survivor, the use of protection orders, sort of going back to screening from a family lawyer's perspective, I'm often and still sort of maybe naively surprised by how sometimes clients aren't aware of the danger they're in. That sometimes people who do come in and share their life story with you very easily will explain very horrific situations. I remember to this day, I had a woman come in and tell me sort of very matter-of-factly that she kept a journal to document every violent incident that happened, so that when they found her dead, that they would know that he did it. Because there's no way she believed that anybody knew about how violent he could be. And her telling me that, like, she was just trying to survive. And often I find that people don't even really understand the immediate danger they're in. Same thing with, I've had clients in my office for a first meeting, and I remember walking with her to the courthouse and having her apply for a protection order. Then I would not let her leave my office, go home or anything for what she shared with me. So of course, in all of this, it's ensuring safety and using protection orders where you can appropriately. Survivors, I find, are also sometimes of course, they feel like they're in a double bind. They have concerns about the safety of a child, but yet they know that they're going to be criticized or blamed to be an alienator. So often they're just frozen and not sure what to do. So in working with those scenarios, you can help as a lawyer, constructively help by putting in place and brainstorming what a parenting plan would look like. It can be interim baby steps. Maybe it can be supervised access. It can be third-party exchanges, some level of parallel parenting. And again, this is not universal advice because every case is very different. And of course, there has to be a safety assessment for every single case. But it's sort of that discussion, because I often find survivors are just frozen knowing or feeling that they're being criticized. And so sometimes I find that they're giving actually more time than they should, especially before coming to a lawyer. It's often common when in an immediate separation for the abuser to demand access, right? And they don't feel that they have the ability or capacity, and they don't often, out of fear, out of survival, to stand up to that abuser. So they're often sometimes allowing that abuser to have more time necessarily than is safe for the child. And so it's that sort of checking in and working with the survivor to come up with an appropriate and needs-based for the child plan. Sort of goes into my point number 4. Is you have to understand also the capacity of the survivor at that time to make decisions regarding the children, because sometimes they're not in a place where they can make those decisions because out of fear and because of fear of being claimed to be an alienator. So in situations where your clients are survivors who are being alienated from their children by the abuser, also, there has to be a close examination, right, of any allegations of the parenting deficiencies of the survivor. Abusers, I find, will often take advantage of mental health, right, issues and legitimate, PTSD issues of survivors as being deficiencies in their parenting. You have to be aware of gaslighting, right? I often see there's a lot of sort of gaslighting going on. I remember also having a client where she would sort of pretend to sort of harshly discipline her children to protect the children. And so what she would do during the relationship was do something that she normally wouldn't do as a parent or feel comfortable of, but she would harshly discipline them to save the children from the wrath or what would be the worst treatment by the abuser. So there needs to be a very careful examination in the context of often what will be displayed as parenting deficiencies. Again, control the narrative early on in the presence of family violence. If there is, again, alienation claims, similar evidence that you need to present on the coercive control, and early intervention, of course, in all cases. And we're very lucky in Manitoba to have a family court system where there is early intervention through emergent motions, and that there is no longer significant delays in litigation, and our courts do prioritize family violence cases. And that's especially important in these cases to avoid long periods where children are withheld, to access emergent motions when you can, to get court orders in place. And also, the reality is sometimes court orders are not complied with, but there needs to be an early intervention in these cases, and early intervention and access to the court if necessary. Again, in parenting plan considerations where the abuser is trying to alienate the children, there needs to be, of course, frequent contact with the survivor. I'd be careful of frequent phone calls and FaceTime. I've seen a lot of inappropriate messaging being done to children over phone calls that is not necessarily monitored. Also monitored communication between the parents with Family Wizard, a program like Family Wizard. And you may need to think of as a lawyer in terms of making an application for exclusive decision-making on certain issues. This didn't come up very clear, but this is a cartoon where it shows one parent, right, passing the children back to the other parent, and says, "There you go, it's time for your brainwashing session." And the other parent saying, "Come along, it's time for your debriefing." And I have to say, this, I mean, this is why the theory of where there is claims of improperly involving the children or alienation, that frequent contact with your client who the other person is trying to alienate from, it's that frequent contact. Because often what is happening in one house when the kids come back to the other parent can sometimes has to be undone. And that's why the parent who is being alienated needs significant support in learning how to respond to comments made by the children when they come back to the house, on things their dad said about them, or complaints all of a sudden they have about the mom. They need significant support, not only from a lawyer, but most necessarily from a psychologist or counselor on how to respond to their children when that happens. So in these cases, coordination of criminal and child protection proceedings, right? There often is intersecting proceedings. And lack of coordination can lead to confusion, survivors needing to retell the same story, inconsistent orders, increased risk to survivor, and really a lack of public confidence in the system when people feel there's not proper communication. It's important to realize that there's different standards of proof for different proceedings. In the criminal proceedings, it's beyond a reasonable doubt. In family, balance of probabilities. There's also different analysis for children. Best interests of children, of course, is of paramount concern in family proceedings, but in child protection proceedings, it is also, of course, an important analysis, but that's different than a child being in need of protection. So in family proceedings, just because criminal proceedings may be dropped or stayed, or a Child and Family Services agency may find something inconclusive, it certainly does not mean that that's not irrelevant to the family law proceedings. So as a family lawyer, you need to be able to get access to the records, which you need a court order for. You need to often coordinate with the Crown and find out the status of proceedings. So it's really the job of the family lawyer at this time to sort of coordinate between those three systems.
Robin, you have about 2 minutes.
Thank you. So I'm just going to quickly flip over these slides because Peter did highlight the changes to the Divorce Act. There's just kind of things in purple I'd like to highlight. Family violence, it's whether or not the conduct constitutes a criminal offense. So it's very much in front and center there that I think a lot of people feel when they come into a lawyer's office, they don't really want to mention the family violence, that they don't think that they're going to be believed because criminal charges were dropped, or they had a very difficult experience in the criminal system. But the definition of family violence that judges have an obligation to consider in the Divorce Act, shall consider, is irrespective of whether the act would have constituted a criminal offense. Again, it's the pattern of coercive control, and it's indirect. Family violence can also be a child's indirect exposure. My last two slides will deal with counseling and therapeutic interventions and access to justice issues. Counseling and therapeutic interventions are necessary, I believe, in almost all of these cases, but I just want to caution that sometimes there is a lack of counseling being child focused. So in these cases, often people will recommend a reunification therapy immediately without understanding the reasons potentially why a child is resisting contact. So the child shouldn't be forced immediately to reunification therapy with a parent, an abuser parent, until that child's trauma is addressed and until the family violence is addressed. Again, some other issues is compellability, expert testimony, assessments, voice of the child, which Peter spoke about. And sometimes abusers will fire counselors, withdraw consent. And in these cases, it's also important to think about getting exclusive decision-making sometimes on medical issues. Again, there's my last slide, interwoven issues of access to justice. Litigation can be used as a weapon to financially exhaust someone. We have a view in our court, I think, of the benefits of a one judge model where feasible and possible, which is definitely something that assists with these cases, that you're not getting a different retelling the story every time, or getting a different view in someone who knows the history. There can be multiple change of lawyers, of course, self-represented litigants. And really, in my view, the meaning of access to justice in these cases is not just access, right, to legal advice or a judge, but it's culturally sensitive and a holistic systems base that also coordinates with child protection proceedings and criminal proceedings. I think I'm out of time.
Great, thanks, Robin. That was wonderful. I mean, just sharing some of your, your real life or frontline examples as a family law lawyer working with survivors, I think is really, really informative. And I know there's lots of questions in the question and A chat that I'm seeing. So thank you. Justice Merwalt, you're up. Would you like to load your presentation?
I'll try anyhow. Well, first of all, thank you for arranging this. I've been a long time fan of Resolve and have used many of your publications and training materials in my practice as a lawyer and as a judge. And I've been a judge for a little over 5 years now. And what's always amazed me is how much people don't tell judges. And so I'm one of those judges. I'm really curious and I want to know things about the case and the people I have to meet. I don't always just look at what's there. So that's how most of my colleagues now practice, because we've come to the realization, I think, that family law and if we're going to help people, we're really going to have to roll up our sleeves and not be so, worried too much about offending anybody or following this rule of evidence from 1812 and that rule of putting in a case. So we've got a huge culture change amongst our judges and hopefully amongst the bar. I'm seeing lawyers like Robin coming into my court and just giving her all and really helping our clients. And that's what we like to see. So I'm here to talk about what we've done in Manitoba to address the concerns, the correct concerns, that professionals like Dr. Jaffe and like Robin Kazina bring to our door. So it is an access to justice issue, clearly. I want you to know that, access to justice is something very near and dear to my heart, having practiced in northern Manitoba, where access to justice was hampered by geography, but also about lack of resources. And people outside of big centers sometimes feel that. And I can tell you as a practitioner, as a lawyer for over 30 some years, I had the lived experience of losing clients, having clients murdered while I represented them in family cases. So the whole idea of making a court system more accountable and more responsive to families is something that's near and dear to my heart. So the Justice Canada has put out, the access to justice as a fundamental right. You could read the slide. It's incredibly important in family law. Having a court system that is expensive, slow, and ineffective can hurt families and put children at risk. So we recognize that. Barriers to justice. Our Chief Justice of our division, Justice Royale, in 2018, he put out our practice direction, which announced our new approach, our family division model, we call it. And our court has been at the forefront of access to justice initiatives. Reforms to criminal, civil, and child protection rules and processes were achieved by 2018. And the last area, perhaps the more complex area, was that of family law. And so you can see that Justice Joyal here recognizes and acknowledges the barriers to justice in family law. Our Chief Justice of the province, Richard Chartier, in a case in 2017, spoke about a better way in family law. And this certainly echoes what the Supreme Court of Canada said in 2014. Former Chief Justice Beverly McLaughlin said that there has to be a shift to simplify pretrial procedures, moving the emphasis away of conventional trial in favor of proportional procedures tailored to the needs of a particular case. The balance between procedure and access struck by our justice system must come to reflect the modern reality and recognize that new models of adjudication can be fair and just. So our impetus for change were delays in obtaining a mandatory first case conference date. We're talking delays that in some cases that took years before you had a meaningful sit down with the judge. Change needed to happen. There's a Canadian Bar Association survey that was done, I think in 2015, that said an average case in Canada, a divorce case, takes 4 to 6 years. Paying your lawyer for 4 to 6 years, that's impossible for most families. Being a lawyer and having this case hang on for 4 to 6 years doesn't do much for your mental health as a family law lawyer. And a lot of lawyers left family law just because of this kind of thing. Very difficult for self-represented parties, and you become a self-represented litigant when you can't afford your lawyer anymore. You start out well, and then it just gets too expensive. Family violence issues were often put to the trial, meaning they were heard last, and findings of fact were made at the end of the case. Meanwhile, either the victim or the children were put in an impossible situation. So we knew we had to act. That's our beautiful main courthouse in Winnipeg. And in December 2018, we announced that a new case flow model will be implemented as of February 1st of 2019 for all contested family proceedings. This did not include child welfare, adoption, guardianships, child abductions, and some others, but the main kind of family litigation was going to be under this model. So we talked to everybody around the court. We looked at all of the studies. We looked at Resolve's studies. We looked at studies across Canada. We looked at studies across the world, in fact, about family law and what different jurisdictions were doing. We talked to other judges, our personnel, the staff, people who work at family resolution services, maintenance enforcement. We held 3 open sessions with the Manitoba Bar. And if you think you're a tough audience, talk to lawyers, especially when you're getting in between them and their income stream and how they used to do things. And I think the majority of the lawyers were there because they were honestly concerned about, how do I do this now? How is this going to help my client? We're doing things so different. This isn't going to work. And so after the 3rd session, we started to get some believers. And I think Robin was one of those, so I thank her for that. We sought input on procedural shortcomings, ways to revitalize and enhance case conferencing. We've had case conferencing in Manitoba for 20 years, but just the way it was stuck in the middle of this old process wasn't helpful. The use of administrative processes to streamline case flow. Did everybody have to come on a certain day? We called it the Tuesday list, and ask a judge for permission to do something. Well, that seemed like a big waste of people's money and waste of judicial resources. So we tried something different. So many, many months of study and consultation went into it. So implemented February 2019, everywhere in Manitoba, and all the old cases had to come into the new case. So into the new flow. So we had processes to kind of shoehorn your existing case to take advantage of the new changes. We changed all the family court rules, and this was the hardest thing to do, and it was hard on the lawyers, but we tried to make them a little bit more user-friendly for the poor self-represented parties. Judges were given new powers to enhance the system and to allow us to make directions and rulings early on. So here's the objectives. Here's what we're trying to get. We want to ensure all reasonable efforts are made to resolve or dispose of a family case at the earliest opportunity. Not in 4 years, not in 10 years, but The first time you meet with us, we want to see what can we do. Ensure greater judicial resources are available at the front end or intake stage. No longer is it a 5-minute court appearance. You're in intake, you're there for half the day. And we are talking to you and we're trying to get things, we're going to drill down into what the issues are. Where cases can't be resolved, we give you a predictable, reasonable, finite time period. So from triage to the end of the trial, our goal is it should be no more than 24 months, okay? Early and active intervention means the judge will take action to protect the party and children at the earliest stage. Clear directions are given, timelines are set, and another date to meet is set. You never leave my courtroom without your homework to be done and without your next day. 5 meaningful events. These are the 5 hallmarks of the system. The first thing is, how do you get into one of these triage conferences? So that is where we see some delay. And people, lawyers will, agree with each other. Well, we'll put off triage while we're discussing it, etc. And that's okay as long as they come up with a resolution. But if one side's dragging their feet, we have court rules that say, if your lawyer gave the other side 15 days to get something to them and they're not doing that, that lawyer can be before a master within a week. A master is a court official that can make orders requiring people to do something and move the case along. So if you are one of those people and you're stuck at the pre-triage stage, you need to start asking your lawyer, or you need to start looking at the rules about how you can get in. I can't help you till you're in front of me. Okay. This is a slide I stole from the Legal Help Center, and I'm going to give them a big shout out. They do fabulous work. The Legal Help Center provides assistance to people who can't get into legal aid, or they don't have a legal aid lawyer and can't afford a private bar lawyer. So they've done this graphic about our case flow model, and I've kind of changed up a bit and put some timelines in it. But how quickly a case moves along is really up to you before the pleadings are filed and before you get to triage. You can be before a judge within 30 to 60 days, depending on the kind of a case. So if it's just custody, access, and child support, boom, you should be talking to a judge within 30 to 60 days. Once you have the date set for the triage, then things begin to work and they're controlled by the judge. It's not controlled by the lawyers, it's not controlled by the parties. The minute triage happens, we're setting a date for either a prioritized hearing, you can see up there, a set-aside hearing for family violence case, I'll talk about that in a minute, and we're setting a first case conference date if we can't settle it. At the first case conference date, we're setting a trial date. You can't get out of the trial unless you settle, or unless one party gives up or both parties give up. We are going to make sure that you don't leave things in limbo. No more adjournments. Nothing is adjourned without a date. So what are we trying to do? We wanted to make it accessible. Mandatory early exchange of information aids you in resolving your dispute. Financial disclosure, pay stubs, information about the kids' school and schedules, all those sorts of things. And how we aid you with that is we've got a prerequisite checklist. So we've got a checklist. And I'm going to tell you that I think self-reps do an amazing job on that checklist. They do a better job than the lawyers do, because the self-reps know the judge wants this. The lawyers go, I don't think the judge needs this, and maybe I can get around it by stroking something out. The lawyers who come to my court soon find out that I'm not a big fan of stroking things out of a mandatory document. So we get along just fine after I explain that to them. Navigability. Are the forms accessible and in a checklist format? Yes, they are. And they are written at a level that most people with a grade 8 education can understand them. So we're taking out some of the legalese that stop people. Time limited, strict timelines. If you want your trial adjourned, you have to ask the Chief Justice. You don't ask me or anybody else. And I can tell you that he's not a fan of adjourning trials unless someone's in dire, health concerns, et cetera, if there's something dire that's happened. Early and effective judicial intervention. Emergent hearings, I'll talk to you about that. We address family violence and denial of access at that point. We start dealing with, okay, you're saying parental alienation, well, what's going on? You say there's family violence, what's going on? So we have that chat with people. Triage conferences, early opportunity to sit down with a judge. One judge model, no jumping between judges, no judge shopping. And I can tell you, being the one judge on a file, sometimes no picnic. Sometimes it's great because you can really work with people, but sometimes people are really resistant or they don't want to, and they're complaining, they're upset with you. So, but there's so much value to the one judge model, and having different judges look at things and getting different results doesn't help anybody. Effective case management. Each case conference must result in a meaningful step forward towards either resolving it, or if you can't resolve it, we're going to get you ready for trial so that you have your best chance to put your best case forward. That's our job, is to help you. The end of litigation abuse. You cannot file a motion in this court without the permission of a judge, either an emergent motion or a motion during the case. So there's no running off and, well, I don't care what that judge said, I'll go to another judge and get an order for something different. That doesn't happen. If you want an order or a motion, you have to come explain to me why, and I bring both sides in and we try and sort it out. I've done very, very few interim motions in this system. The end of the prioritization of family violence, that's key. We hear it at the beginning, not at the end. So findings of fact are made early and they're binding. This is throughout the province. And the pandemic has taught us that personal appearances aren't necessary. They're preferred, but they're not necessary. And when you have family violence, forcing an abused person and the abuser in the same room can create risk. And it also mutes the conversation. So if I'm aware of that, I may make arrangements for people. And certainly during the pandemic, we did that. Sometimes people are out of town because they have to work. The telephone, we've used that. We've used video phones. So the new system is available everywhere in the province. And if you're a lawyer, if you're outside of Winnipeg, your lawyer's not using the new system, going to provincial court, talk to your lawyer about whether you want to stay in that system or come into Queen's Bench. So how do we address family violence under the model? Well, we address it. So you get your protection order at the counter or over the phone with a JJP. And that's under the Domestic Violence and Stalking Act. That process is still there. It's not changed. Nothing under Domestic Violence and Stalking Act was changed because of our model. We have to accommodate that statute and that law within our new system. So how we've done that is that you can still go to the counter, get your protection order. If the other side objects, they have to file their application set aside. That list is every second Wednesday, and they try to resolve as many issues there on a consent basis or putting the matter over to a short date for a summary judgment on a summary judgment basis to either confirm, set aside, or vary the order. If you have an existing family matter and you've got a triage date or a case conference date, that application joins your family case and the judge is dealing with it. Even if I'm not dealing with it and one of my colleagues has made a decision about domestic violence, I'm taking that into account. So once you're before me, we have quick hearing dates for that. So if you're before me at triage within 30 days, I'm dealing with your domestic violence set aside and I'm making findings of fact. Those findings of fact are crucially important. As it says here, this is from our practice direction, proceedings will have the necessary determination of fact regarding the issue of family violence made in a timely manner for the purpose of the court addressing any ongoing eventual custody, access, and property issues. So family violence doesn't just affect children, it does affect the victims, and it does affect, the control of property, the financial violence that goes along is something we're attuned to.
Justice Merwalt, you have a minute and 30 seconds.
Okay. Well, the types of family violence are there. Here's why it's important. Not all family violence fits in there. We're aware of that. Robin spoke about those parallel judicial processes, criminal court. A trial can be 2 or 3 years later on the same facts. Child protection, very fast. You're having a trial in 6 months, and then you come to ours. So you can see we've got differing processes and objectives. All right. Donna Martinson, this is one of my favorite quotes. Criminal courts order no contact. Child protection authorities say the children would be apprehended if you allow contact. And the family court focuses on the view that contact's in the best interest and grants unsupervised access. This is what we're trying to avoid. And we're avoiding it by using our processes. Here's the emergent one: immediate or imminent risk of harm to a party or a child. And the practice direction, you'll see this on the slides when you get a copy of them, is basically about where one parent abruptly, unilaterally, and without explanation or apparent justification cut off or virtually eliminates access. That's the parental alienation cases. And when they come before me and the other person says, well, he beat me up, he did this, he did that, I think they've justified not allowing that, not allowing the access. And then I work on a safety plan. How do we fix this situation if I can? Prioritized hearings, again, hearings on matters that should not wait for the first case conference. So if you didn't get an emergent, I'm going to be dealing with it. Our judges are dealing with it on a prioritized basis. Sometimes they make the order right at triage. The Divorce Act amendments, we must consider family violence anytime we make a custody order. So even if it's not pled, the inquisitive judge is going to be asking you, is there any family violence? Can you address this? Can you think of anything? And we will address it. We have a Family Law Modernization Act in Manitoba, enhanced power for maintenance enforcement. We're part of a bigger system. We know that, and we will work with those systems, including women's shelters, counselors, CFS, all of these things. We all work together on this. And this is where you can find information. So I hope I haven't run too much over, Dr. Nixon, but thank you very much.
Great. Thank you so much, Justice Merwalt. I know 20 minutes isn't a lot of time and a lot of changes that you spoke about. So thank you very much. And lots of questions for you as well. So now I know I'm just looking at the time. I think we might run about 5 minutes over, if that's okay. I'd like to leave about 15 minutes for questions. Perhaps while I'm doing that, Patricia, if you can put up our PowerPoint presentation, because we'll be needing to give information about the survey as well as the links. So Peter, perhaps the first question for you. Do alienators have an increase in use of custody evaluations, voice of the children's reports, and increase in social service investigations?
Just to be clear on the question, does the question mean are alienators more likely to use those tools?
I think so, yes. Do they use those tools as a way to alienate?
Well, I think once you're going down the alienation rabbit hole and you want to stick with that, you'll use everything at your, everything that's available to you. So certainly alienators can misuse voice of the child reports. They can misuse custody evaluations. So it's obviously important to have good standards of practice and training for those professionals to be aware of what are legitimate claims and what are false claims. My number one worry these days is litigation abuse, that often abusers want to drain their partner financially and emotionally, and it's important to recognize that early on. So I think people who want to pursue that will use every tool possible.
Okay, thanks, Peter. It looks like there's a participant who is a practicing family law lawyer in Manitoba who's experiencing a really bad case, significant assault. And the question is, this is a case of severe intimate partner violence. How can this be handled as the majority of LAM lawyers, I'm assuming Legal Aid Manitoba lawyers, believe the father has the right to see his children. I don't know who wants to take that one, Robin or Justice Merwald. But I guess, what do you do with, other lawyers who believe that it is the father's right to see the children, and making the assumption that it is the father who is doing the assaulting?
Robin, I think you probably have better experience.
Sure. I mean, I think in those cases, people get overly focused on the rights of the parents, right, over the rights of the child, right? It's my right to see my kid. But I think refocusing on the child's needs and getting potentially some input by an expert on the needs of the child would be helpful. And refocusing the debate on, sort of on parental rights versus child's needs. Of course, it's in the normal case, it is in the best interest of a child to have normally a contact or relationship with both parents, but that's not necessarily immediately after separation. In cases of significant family violence, I believe, usually an abuser will have to show significant efforts to change their actions and beliefs in order to ensure that that child's safe. So, I mean, it's really up to that. You are, of course, going to be up against people who have different views, but to refocus it really on the child would be my recommendation, and getting some expert evidence there on the perspective and the needs of the child.
Okay.
Can I just jump into that question?
Sure.
Since it's safe to answer from Ontario. This is not a problem we have here, but no, I think the key thing is legal education. I think it's important that obviously every practicing lawyer, as part of their ongoing licensing, needs to involve professional development, and certainly being aware about domestic violence, family violence, and alienation is, I think, important. I think the law has changed. The law has changed dramatically, obviously, with the Divorce Act and certainly legislation in Manitoba and other provinces and territories. So I think ongoing professional development is going to be the key, because the law changes, but people don't unless they have the education to keep up and then work through cases with this new information.
Okay, thanks, Peter. While we have your mic on, a question for you. How can intervention prevention clinicians respond to participants who make allegations that their children's mother is withholding contact, especially if the participant does not believe they have used abusive behavior, and if the children are too young to verbalize their refusal or resistance?
Well, I think there's no shortcut to a thorough assessment, and I'm not sure Robin and Judge Merwald could answer more about access to assessments, but clearly a independent third party has to get involved to interview the parents to understand the history, and also interview the children or observe the children and parents. I think they're complex allegations. They need to be sorted through. I think one of the, and I mentioned this in my talk, I think a lot of people only think abuse is physical. Like if you haven't threatened with a knife or gun, or there's no black eye or broken limbs, no medical reports, there's no violence. And I think we have a whole new meaning of what family violence means. So I think I see lots of people who would admit all kinds of things that are part of coercive control, but don't think they've ever been abusive in their relationship. It's the way they were raised, the way they were socialized. They don't see it when they've lived it themselves. They may have grown up with it. So I do think it takes an assessment, not only to recognize the violence, but also understand the potential impact on their ex-partner and also on their children.
Okay. All right. Thanks, Peter. This question is for you, Justice Merwald. What has the impact of the new family division case flow model on litigants that were engaged in the process prior to the change? From my limited experience, shoehorning the existing cases has created significant delays in varying final orders.
All right. Well, I'm not sure, I'd have to know the particular case, but I can tell you that every existing case that was scheduled for either trial or a case conference was assigned a judge if the other judge was retired, and we had many of those cases. We started from the beginning. We went through the checklist with them. We made sure, and if you're talking about a variation, variations happen very quickly in our court, and it is a true one-judge model. So if you're there for a variation, your case conference judge is also going to be your trial judge. So, and those trials are set within 120 days. So it's a very quick process. But the cases that didn't yet have their first order, they were put into the system. If they didn't have a trial date set, they would get the trial date immediately set. And if they did have a trial date set, we'd work to help them. So I'm not aware of any case that suffered significant delay that I'm aware of in the new system. And I'm part of the group of triage judges, and I don't say you're wrong, but I'm not aware of that. And we specifically designed the system to make sure we weren't causing further harm to people. Just because you had a trial set didn't mean you had to go back in time and do things. We let those trials go ahead, and it took about 18 months to get through some of the old cases, but we did it, and they're all new cases now.
Okay, thank you. Peter, this is for you, and it's more kind of research oriented. We have in the last number of years seen cases where accusations of parental alienation, quotes, have resulted in reversals of custody. Has anyone, academic or otherwise, followed these cases to see what the outcomes have been for children?
That's an easy answer, no. So there's a lack of good follow-up research. And in fact, it's a very difficult area because there's lots of decisions being made that go in a variety of directions, lots of interventions, but we're missing follow-up data. And even if we do, there's not really good comparison groups. For example, a lot of the alienation treatments, there's no comparison group of children who are left alone. There's no comparison group of children who are given other kinds of counseling. So we're basically flying blind.
Yeah, okay.
Actually, Kendra, if I could, I really like the last question posted, which I think which might be, I'd be interested in hearing. I can start it off and hear from Robin and Judge Merwell, but there's a question about counselors refusing to provide therapy for children who are in the middle of custody and access disputes. So a lot of counselors, and parents reach out to get counseling for their kids in the middle of one of these, we'll call them high conflict situations. The counselors refuse to get involved because lawyers in the court are involved. They don't want to get dragged into court. So one of the things that I try to do in our jurisdiction is encourage people to get involved in counseling, but give the counselor an agreement that they'll never be called as a witness to court, because we have lots of children who are in crisis because of what's happening, and the court may drag on for years. The children aren't getting the treatment, and the parents are reluctant, and the children may be reluctant because everything they say with the counselor could be subpoenaed or drawn into court later on. And I wonder what the practice is in Manitoba. So my preference is to provide counseling for children and to have a clear agreement from both parents that that counselor will never become a witness in court.
Okay.
Yeah, I've seen that, Peter, and it's all about the best interest of the child, not about proving a case or being a servant to the court on something. And all counselors in Manitoba have a duty to report if there's a need of protection, et cetera. So there's plenty of protection for children and for the circumstances. So I've seen that. I'm just happy the kids are talking to somebody and seeing somebody they need.
Yeah, I've seen that as well. I think it's very common amongst lawyers to reach an agreement amongst the two lawyers that and we confirm it in writing that counselor won't be compellable, especially when, that child needs help and everybody just wants to get that child help. It would look pretty bad on the other party if they were, in circumstances, if they refuse their child getting help because they wouldn't be compellable in some circumstances. But I've also have had counselors who necessarily don't want to be subpoenaed as a witness, but will speak to an assessor. The assessor is completing the report. They don't want to be subpoenaed and cross-examined necessarily at the trial. And sometimes that's a kind of a nuanced approach that at least they'll be able to share their information with the person who's completing the assessment.
Okay, thanks, Robin. Justice Merwald, a question for you. What are your thoughts on Bill C-233, otherwise known as Kira's Law, to expand judicial education on domestic abuse?
Well, I don't know the particular statute, so I'm not going to comment on that, but I can assure you that as family court judges, we get judicial education constantly. This is one of the top subjects. I recently lectured to the Manitoba Bar Association on family violence and family law. So this is top of mind for us. We have a new legal duty under the Divorce Act, and as family judges, we cannot grant custody without considering family violence. So it's a matter of judicial competence and information, and I can tell you all of my colleagues are engaging in it. So if that's the point of the law, then fine. But like I said, I haven't read it. I apologize for that. This is the first time I've heard of it. So maybe I need to be a little bit more aware about that. So thank you for bringing it to my attention.
Okay.
Actually, I could give you context if you want, Justice Merwald. So Keir's law refers to a child in a parent murder suicide with her dad after years of litigation, and obviously the mother, Jennifer Kagan, in that case was approached the federal government and has support from member of parliament to bring in legislation to have mandatory judicial education around domestic violence issues, parallel to legislation that was brought in around the issue of sexual assault. So that was the that's the legislation.
Okay, if we have maybe time for one more question, and I will maybe give this to you, Justice Merwald, or perhaps Robin, you might know as well. So we've had these, the law reforms that you spoke about, Justice Merwald, as well as the family modernization pilot project. Have survivors been involved in these in either consultation processes? I've had a few people ask that.
Yeah, we relied upon the people who are helping the survivors rather than, trying to put together a group of survivors. So we really relied upon, people who are doing that work. We relied on collaborative lawyers we met with. We relied upon the bar and legal aid and other people who provide those services. Family Resolution Services was involved, Legal Help Center was involved. So as many advocates for victims and parties were involved in our discussions. Perhaps Robin can speak to that.
Sure. For the family modernization changes, I'm part of the collaboration table, which involves a number of different people from a number of different sectors. And I do believe there was definitely victim services, and definitely I believe there was survivors involved in that. So for the family modernization part, there's a collaboration table that involves people from multiple sectors in terms of those changes.
Okay, well, I think that concludes our question and answer period. It is 3:35. We've gone a little bit over. Again, I just want to thank our three presenters. That was excellent. I mean, the issue is so big and, like you said, Peter, so contentious. So I just want to say thank you very much to all three of you. You'll see that we have a survey. So again, this is part of a larger study. And so for all of our webinars, we do ask participants to complete surveys. What did you like about this? What you didn't like? And also, topics for future webinars. We're committing to hosting about 10 webinars for this project per year. And I see that we have posted the survey link in the chat. So again, please take the time to do that. And again, so here's a little bit of information about the Alliance. So again, the Alliance is a consortium of 5 research centers of gender-based violence across the country. And this community of practice project involves all 5 centers. So, so there's some information on here about the center, as well as the Alliance website, where you can access not only webinar recordings, but also briefs about different law issues, law concerns, and written material of other webinars that we've presented on. So for example, technology facilitated violence. I know someone had a concern about social media and violence against survivors. So again, I just want to say thank you to everyone who attended. Please stay connected with Resolve. We have various means of social media for you to kind of stay connected. So please do. Again, we have posted the survey on chat, and we will post the slides as well as that information on parental alienation resources, as well as the link for the upcoming international webinar on parental alienation on the Resolve website, as well as the Alliance website. So again, I want to thank Patricia and Ashley and the Manitoba IST team for managing and ensuring that this runs smoothly. So thank you very much. And of course, thanks to all of you for attending, and thank you to Peter, Robin, and Justice Merwalt for such a fascinating presentation. So thank you very much. And we will see everybody another time. Take care, everyone. Bye-bye.